Hello everybody, Martin Radner here from Radner Law Group, bringing you trial analysis. We are jumping again into the Melly case. There's been some more action on the Melly case. Another motion that the state attorney's office filed, and we're going to jump into that. It has to do with the death penalty that's related in this case. If there's conviction, as we all know, the death penalty is an option that could be applied to Melly if he is eventually convicted during this second trial of the murders of Christopher Thomas and Anthony Williams. So we're going to jump out into all of this discussion about the death penalty and what exactly the state is asking at this stage of the case in just 1 second. But please, if you haven't yet, please subscribe, like the video so we can continue growing and bringing this important, unparalleled trial analysis to more people. So what do we have in this case? We've got the death penalty is on the table. And what determines whether the jury can find that the death penalty should apply in this case? Well, there's certain factors that the Florida statute tells the jury that they have to consider, which the judge is going to instruct the jury that they have to consider if there is a conviction, whether the death penalty should apply. And there's two categories. There's aggravating factors and there's mitigating factors. Okay, aggravating factors are that the idea is that we don't just look at the murder in a vacuum. We don't just assume, okay, well look, at the end of the day, person A killed person B, and it doesn't really matter all the other details about what other factors that went into the murder. No, we don't look at it like that. We actually look at the other factors that went into this murder. So there's aggravating factors to look at and mitigating factors. The aggravating factors is what make it worse. That makes this crime that much worse. It's not just somebody shooting another person. It's much more heinous than that. And as everybody knows, there is this questionable whether Melly was affiliated with this gang. And that's why the prosecution spends time about it, because that's an aggravating factor. That's one of the 4 aggravating factors that are relevant in this case. There's a whole list of aggravating factors, but what's relevant to this specific case with the Melly case is that there's really only 4 possible aggravating factors. One of them is that he is affiliated with this gang. The other 3 are the following. Number 1, was this capital felony committed for pecuniary gain? Was this committed in a way that Melly could financially benefit from it? And that's why there's been some evidence during the first trial, will probably come out during the second trial as well, that really there was a partnership between Melly, Christopher Thomas, Anthony Williams, all with YNW brand. And by this way, by him murdering Christopher Thomas and Anthony Williams, then Melly will be able to keep more money for himself. So there was a suggestion that this aggravating factor could be present in the Melly case. Number 2 is that the capital felony was especially heinous, atrocious, or cruel. So how the murder was actually carried out. Was it a cruel murder, or was it just a shot that nobody saw, that was just a simple shot? It wasn't such a cruel murder. Now there could be arguments that in this case this crime was heinous, was atrocious, and was cruel. So that was another factor that possibly can lead to. Now it wasn't a long torturous murder, as we all know it, as the evidence has shown in the first trial, which will probably come out in the second trial, is that the Christopher Thomas and Anthony Williams didn't even see the bullets coming. If we buy the prosecution's story that this is all for Melly, wasn't a drive-by, then these people, and there's been evidence of this, that Christopher Thomas and Anthony Williams had no idea that the shots were about to be fired. So it wasn't like this long, drawn-out murder. It was quick. So the question of whether this part of the aggravating factor we consider by the jury is, it's not the greatest aggravating factor that the jury can consider. Number 3 is that the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. So this is another factor that they can be taken, that it was cold, it was calculated, and if this happened, this was cold and calculated and premeditated, and that also would be another aggravating factor that the jury can consider when they're thinking about whether they should impose a death penalty if, again, this is all if there is a conviction on Melly at the conclusion of this case. So those are the aggravating factors, but what are the mitigating factors? So some of the mitigating factors are the following. Number 1, the defendant, first of all, I didn't explain. What is a mitigating factor? A mitigating factor is where there are reasons that we should not be so strict with this person. This person has some other mitigating factors which should lessen our feeling of anger against this defendant, because there's some reasons why he committed this murder. Maybe he was under duress or some other factors that caused him to commit this murder, which really wasn't so much his fault. So for example, one of the things is if he was under the influence of extreme mental or emotional disturbance. Was did Melly have an extreme mental or emotional disturbance? And I know from some of the comments that some people feel that he did. That some people are already feeling that he did have a mental or emotional disturbance, and therefore that can be a mitigating factor. Another mitigating factor is that the defendant has no significant history of prior criminal activity. What type of rap sheet does this person have? What type of rap sheet does Melly have? And he does have some previous criminal activity associated with guns. Not an extensive, but there certainly is a criminal history. So that could play into some of them if this would be a mitigating factor. How extensive is his criminal history? Another one is the defendant acted under extreme duress or under the substantial domination of another person. So if it's brought out that perhaps Melly was under duress from the gang, maybe the gang said that we're gonna kill you if you don't do this. So that could be a level of duress. Now, of course, he shouldn't have been associated with the gang in the first place. But taking a look at if somebody did threaten Melly that if you don't do this murder, then we're going to kill you, that could be that it was committed under duress. That could be a mitigating circumstance. There's another mitigating circumstance, the capacity of the defendant to appreciate the criminality of his or her conduct or to conform his or her conduct to the requirements of law was substantially impaired. So did he really understand the consequences of what he was doing to this person? Did he think this was a game? Did he not really appreciate the criminality of his conduct? Or even if he did appreciate it, was he not able to conform it for some reason to the requirements of the law? Another mitigating circumstance is the age of the defendant at the time of the crime. We know that Melly was very young when he committed this crime. So the age of the defendant also plays into this. Not a person who's already lived a lot of his life, and it's much more of a mature decision. It's a very immature decision. He was still, I believe, 18 at the time when he committed this murder. So he's very young. That could be a mitigating factor as well. And also, the final one is the existence of any other factors in the defendant's background that would mitigate against the possession of the death penalty. Is there any sort of factor that has to do with the defendant's background? How was he raised? How was he brought up? Was he brought up in a crime-ridden neighborhood? Was he brought up with bad influences? Did he not have good mentors? Did he not have good parents? Was there bad parenting? What was his school like? So that also could go into the mitigating factors when the jury decides whether to impose the death penalty or not. So you have these aggravating factors and you have the mitigating factors. And part of what the jury is supposed to do is to weigh them and to decide whether the death penalty is still appropriate according to those factors. Now, what does this have to do with jury selection? Well, this has a lot to do with jury selection because one of the things that the defense is trying to determine is this a jury that in case we lose the case and Melly is convicted, we have to know whether this is a jury that will likely go for the death penalty or likely would rather opt for the life without parole, which is probably what most people would prefer, to have life in jail without parole instead of having the death penalty imposed on them. So part of what the job of the defense attorneys is to not only see whether they have a good jury that will hopefully lead to an acquittal, but also that in case there is a conviction, maybe they won't impose the death penalty. So that's part of what's going on during voir dire, that the defense is going to be asking certain questions to determine whether this is a jury that's going to impose the death penalty. Now, something that a lot of people don't get to see when you're watching these televised trials is we don't get to see the jury selection. And there is a lot, so much that goes on during jury selection. There's been books and books written on different tricks and different things to do for that lawyers should do during jury selection to determine, what type of person you're dealing with. Is the person going to buy some of your arguments? What questions should you ask? There's a lot of research, a lot of psychology, a lot that goes into the jury selection. And that's why it would be very interesting to watch the jury selection, especially in such a case like this, a murder case where there could be a death penalty on the table. And there can be a lot of different tricks that lawyers can engage in to already start swaying the jury towards their side of the argument. So this is across the board. You always have lawyers that are trying to do a lot more during jury selection than just to see whether this jury is prejudiced or has biases against their client or not. It's a much more complicated process, and it would be great to be able to break down and analyze for the masses. But we don't get to see it, so but you should know it goes on. So the state is understanding that, and therefore the state is filing a motion about they're asking the court to limit the certain types of questions that the defense is able to ask this jury with regard specifically to the death penalty. Now, something you have to understand is that there's two different types of challenges which an attorney is allowed to challenge. Meaning when we say challenge, it means to dismiss a juror. So you want to challenge a certain juror means that you want to dismiss that juror from sitting on this jury for your client, for your case. And there's two different ways. There's challenges for cause and there's preemptory challenges. Challenges for cause are unlimited. Each side gets an unlimited amount of challenges for cause, because challenges for cause simply means that this person is completely unfit to be a juror. It shouldn't, right? Out of the context of challenges for cause, each side is limited in the amount of challenges that they can just decide to throw off a juror that they don't like. So no attorney wants to use up their challenges, and the challenges for cause are unlimited. And the reason for that is because if a juror is completely, totally unfit or completely biased against your client, and it's obvious to everybody, so then you should be able to challenge that juror for cause, and the juror and the court, the judge, should dismiss that juror without costing any of your challenges. So you're always trying, as an attorney, when you don't like a certain juror, you always would rather dismiss that juror for cause. Now, there could be reasons to dismiss a juror for cause just because of the way that they feel about the death penalty. So this is where it gets a little interesting, because the defense attorney is going to try to bring out certain biases that a potential juror can have towards the death penalty, and therefore be able to use a challenge for cause against that juror and not waste their preemptory challenges. Preemptory challenges is when you just don't have a good feeling about a certain juror. You don't think he's going to be a juror that you want to hear your case. You just think he's going to be, you're just not getting a good feeling. He's rubbing you in the wrong way, or she's rubbing you in the wrong way. You just don't want this juror on your jury. So preemptory challenges is you don't really have to give a reason why you're dismissing this juror. Of course, it can't be racially based. It can't be based on the other protections, ethnic origin, and it can't be based on that. It just has to be based on some reason that can make sense. And again, to challenge those preemptory challenges are going to be very difficult, or to object from one side to object to the other side's preemptory challenges is going to be very difficult. Once you say you want to use a preemptory challenge on a certain juror, then usually the court will just allow you to just dismiss that juror without giving any specific reasons or arguments why you don't want that juror to sit on the jury. So here, what the state is specifically talking about is the challenges that the defense is going to try to challenge for cause with respect to the death penalty. Now, how should a defense attorney be able to ask questions about the death penalty? What type of questions are you allowed to ask the jury when you're talking to the jury? What type of questions should you be allowed to ask specifically when it comes to the death penalty? So this is what this motion is about. And one of the things also that both sides are always nervous about is that you don't want the attorneys to start trying their case during jury selection. You don't want them to be able to start planting seeds, even though the attorneys try to do this. Trust me, they try to do this. They try to plant seeds already to try to get the jury on their side already. So they don't want each side is not going to want the other side to start trying their case, essentially. That's what they call it, trying your case during jury selection. So this is what the state is very nervous about in this case. And that's why they're filing a motion that they're telling the judge that the judge should order the defense attorney to be very limited in what they're allowed to ask the potential jurors. And specifically in this motion is talking about the death penalty. And so what are you allowed to ask? So the state brings some case law, which is in Florida. This case law that says the following. It says that in a death penalty case, a juror is only unqualified based on his or her views on capital punishment if he or she expresses an unyielding conviction and rigidity toward the death penalty. So if there is an unyielding conviction and rigidity toward the death penalty, which essentially means if they won't follow the law about weighing the aggravating factors and the mitigating factors. They're not going to do that. If a juror says, look, if you prove to me that Melly murdered this person, first-degree murder, if you convince me, I'm going to automatically vote for the death penalty. I don't care about the aggravating factors. I don't care. That's how I feel. I feel that if you murdered somebody else, you deserve to have the death penalty, and I don't care about any other factors. So if a defense attorney can get a juror to agree that that's how they feel, then he should be dismissed for cause. And the state agrees with that. And the state is saying, okay, that's okay. You can go ahead and ask that question. You can ask a question about, are you just going to give him the death penalty automatically? without weighing these factors. That the state's okay with. The problem that the state is foreseeing and that the defense may try to do is they may try to start talking about the aggravating factors and the mitigating factors. So what they're asking in this motion is that the defense attorney should not be allowed to discuss the aggravating factors and mitigating factors. What would that look like? That would look like if the defense asks a potential juror, so let me ask you a question, juror. Let's say there's a gang affiliation. Let's just say there's a gang affiliation. What would your feelings be in that situation? Would you give the death penalty or not? So that you're not allowed to do. Now you are allowed to ask, and this is also what they state in their motion, you are allowed to ask hypothetical questions. Hypothetical questions during jury selection is okay, as long as you don't get into the actual facts of this case. Of the case that's in front of the jury, you can't get into the facts of this case. So you can't pretend that you're asking a hypothetical question. So like, it would look like this. This is how the question would look in the jury selection in the Melly case. Mr. Smith or Mrs. Smith, let me ask you a question. Let's say you've got somebody who's in a car with three other friends, and they're traveling one day late at night at 3 a.m., and they make a stop off somewhere, and you've got cell phone data that says this, and you've got, you don't find the weapon, but you find some shell casings, and you kind of give exactly what on in this case, and you present it as a hypothetical. And then you tell the jury, so what would you feel about in that case? Would you think that person should be convicted, or do you think that he should be acquitted? You can't do that, okay? And you also can't do that when it comes to the death penalty. You can't say, Mr. Jones, would you, if there was pecuniary gain in this case, or if there was a gang affiliation, but the person's very young, right? The person's only 18, and he grew up from a very troubled childhood, and he's got some emotional and mental problems. What would you do in that case? Would you give him the death penalty or not? That the state is asking that the judge order the defense that they're not allowed to do. You can't do that because then you're actually using the facts of this case to see how the jury's going to vote in your case. That you're not allowed to do. So that's essentially what they're asking. That's what they're asking in this case, that when it comes to the death penalty, all the defense should be allowed to ask is, do you just have a predisposition to the death penalty? What's your feelings about the death penalty? Will you automatically give the death penalty? Will you weigh certain aggravating factors against mitigating factors before coming? Do you understand that life in prison is sufficient? Under the law, life in prison without parole is completely fine. That's okay also. You're just asking the jury if they understand that the law does not require them to give a death penalty, even if they find all the aggravating factors are there. So that's okay, but the minute that you get into hypotheticals and you try to bring out facts from this case, that's what the state doesn't want. And that's what they're asking in this motion, that the defense should not be able to ask hypothetical questions that get into the facts of this case. So that is this motion. They're asking that they shouldn't be able to try their case during jury selection, and we'll see. Again, there hasn't been a response yet. This was just filed today, November 1st. There hasn't been a response to this filed by the defense. Maybe there will be, and we will see what the judge orders in specifically when it comes to this motion by the state attorney's office. Okay, that's it for now. Looking forward to next time.